Issues related to the constitution, so local reservation in the private sector. Haryana government has challenged in Supreme Court the order by the Punjab and Haryana High Court to hold 75% quota in the private jobs for the local. So the Haryana State Employment and Local Candidate Act came into force January 15. Maharashtra, Andhra Pradesh, Karnataka, Madhya Pradesh is already tried to reserve private jobs local, but all of them has run in hurdle. So the related information on the issue of the legislation Sons of the Soil. So announcement of the Madhya Pradesh government to reserve all government jobs for the children of states. There is question related to the fundamental right to equality. Article 16 guaranteeing equal treatment under the law in matter of the public employment of prohibits states from the discrimination ground of birth and residence. No citizen shall on ground only religion, race, caste, sex, descent, place of birth, residence of any them be ineligible to the discriminate against the respect to the employment of the job. The provision is supplementary by the others clause and in the questions that guaranteed equality. Article 16.3 is the provision an exception by the saying that Parliament has made a law prescribing a requirement of residing for the job in a particular state. This power rests solely in the Parliament, not state legislature. Why does the Constitution prohibits the reservation based on the domicile? So the Pradeep Jain versus Union of India, that court expressed in the opinion that such policies would be unconstitutional, but did not expressly rule on it as case of on the different respect of the right to equality. And the Supreme Court invalidated appointment government teachers in the Rajasthan, in which in the state selection board gave preference to applicant belonging to the districts or the rural area of the district concerns. And this Allahabad High Court struck down a recruitment notification by the UP Subordinate Selection Commissions prescribing preference for the women who are original residents of UP. And the Sunanda Reddy versus State of Andhra Pradesh of Supreme Court affirmed that the Pradeep Jain the strike down a state government policy that gave 5% extra weightage to the candidate who will study with the Telugu and medium in the instruction. So this was prescribing about the there will be the Sunanda Reddy case of Andhra Pradesh and the Pradeep Jain case of Union of India, and this is Allahabad High Court struck down there. This all are the cases. Now OBC reservation background. First background classes the commissions of the 1953 of the Kaka Kalekar, and the secondly backward classes commissions were the BP Mandal. 27% reservation Article 16(4) and the creamy layer criteria invoked for the Supreme Court in the Indira Sani case. So 27% for the Article 16(4) and the Indira Sani case. Second backward class commission was BP Mandal and the backward class commission was Kaka Kalekar. So Union government had constituted a 4-member commission headed by the Justice G. Rohini. Article 340 with aim to improve the equality of the sharing of benefits of OBC. OBC is a collective term used by the government classify which educationally socially disadvantaged backward classes. 340 of the Indian Constitution laid down the condition for the appointment of the commission and vises the condition of the backward classes. So annual income will be the 8 lakh or above. It's not eligible to the reservation. Creamy layer was introduced the Satnatham Commission and other conditions reservation laid down a Sani case reserved to the socially and educational backward classes. 50% cap of the vertical reservation, and there should no reservation in case of the promotion. So the National Commission for the Backward Class was statutory under the National Commission Act, and is 102 Constitutional Amendment Act made it constitutional body under the Article 338B of the Constitution. So grievance related to the non-implementation reservation, economic grievance, violence, and people will be able to move to the Constitution and to inquire into the complaints of the deprivation of right and safeguard. So 27% reservation will be jobs, education among the caste of community with reference to the central OBC list and the mechanism, criteria, norms, parameter in the scientific approach, subcategorization of OBC. The OBC will be the into 4 subcategories 1, 2, 3, 4 and split the 27% into 2, 6 and the 10% respectively. The 11 state UT, Andhra Pradesh and the Puducherry, Karnataka and the Jharkhand, West Bengal have subscribed OBC for the reservation in the state government and institution. Development with the regard to the 102 amendment is for the Article 338B and 338A. It's deal with the structure, duty, power of the National Commission for Backward Classes and give the President the power to notify a class and the power of Parliament to alter the central list. Ministry of Social Justice and Empowerment was framed the amendment to the Article 342A 127 to include this clause Article 342A in the restore the power of the states identify OBC to include it on the respective state list. Until now, state government were free to decide which caste will be the part of the OBC list and own state separate OBC list down center each of the concerned scenes. Article 15.4, 15.5, 16 expressly conferred power to the state to identify and declare the list of the socially and educationally backward classes. However, Supreme Court ruling the Maratha reservation held that only the President can declare any community as OBC and that too only the recommendation of the National Commission for the Backward Classes. Additionally, Supreme Court has also remarked about there is being future a single list OBC that should be issued by the Presidents on the recommendation of National Commission for Backward Classes. So other backward classes and the economically weaker section get quota under the All India Quota Scheme for medical courses. Union Health Ministry has announced 27% reservation for OBC, 10% quota for EWS in AIQ scheme for upgradation and postgraduate states in medical and dental colleges. Introduced 1986 for the domicile free merit-based opportunity to the students from the states, and it's comprised 15% UG seats and the 50% of the PG government medical college. No reservation in AQI for this, so reservation of the SC and ST will be the scheme. Article 15 provide the special provision for the advancement of socially educationally backward classes tribes and admission to educational institute based on the provision Article 15 527% OBC higher educational and introduction central government medical institution was implemented 2006 and 7 but didn't include medical and dental courses seats All India Quota OBC. In the 103 constitutional amendment, 10% reservation for the EWS is for the EWS. 103 is for the higher educational institution. Article 15(6)(b) and but in it also exclude the medical and the dental courses for the All India Quota. Centers considering moving a review petition before the Supreme Court to allow the political reservation of OBC in local bodies and municipal. So its Supreme Court is strike down the 27% reservation in the favor of the other backward classes in local bodies and Madhya Pradesh. So Supreme Court ordered the Krishna Murthy judgment stressing the barrier to the political participation not of the same character of the barrier assessed to the education employment. So setting up the dedicated commission to conduct a contemporaneous religious empirical inquiries and proportion of reservation required to be provision local bodies, while recommendation commission reservation should be exceed aggregate 50% of this basic structure. So Keshwanand Bharti Shri Padagalvaru other versus State of Kerala. It's Keshwanand Bharti judgment of Supreme Court was structure of constitution. So this is various elements. Sovereignty in India, essential feature, individual freedom, mandate to the build a welfare state, supremacy of constitution, reputation and democracy of government, secular and federal character of the constitution, separation of power between legislative and executive, judiciary, unity, integrity, power of judicial review, harmony, balance between the fundamental right, DPSP, parliamentary system, rule of law, principle, equality, free and fair election, independent judiciary, limited power, parliament amendment, constitution, effects of the assess justice, principle of fundamental rights, power of Supreme Courts and the power of High Courts. So Kerala reforms as violation of fundamental rights enshrined in Article 25, 26 and 31. Its bench was the 13 judges, the largest formed the Supreme Court. A hearing proceeded. The scope of the was expanded to the address the interpretation of Golaknath case and interpretation Article 368 power of Parliament to amend 24th Constitutional Amendment 368 24 Constitutional Amendment Act Section 2 and 3 of the 25 Constitutional Amendment and 29 Amendment was there. So this is Parliament can amend the Article 368 Sanket Prasad case and the Sajjan Singh case 24 and 25 for Section 2 curtail right to property with the due compensation. Section 3 precedence of the DPSP and fundamental rights judicial review. Article 39B and C and 29 CA was added to land reform legislation for the 9th schedule. 368 did not confer the amending power to Parliament, but the cannot be amended by the Parliament. And the Keshwanand Bharti case was the line of thought maintained and strengthened in the subsequent judgment. Mindra Mill, Bomai case and the Kohlo case was there. So constitutional amendment CAA constitutional amendment Act was there, upheld the valid 24 amendment parliament and power. So there is the Sajjan Singh case, Shankari Prasad case, and 368 did not confer the amending the power to parliament but cannot be amended by parliament. This is 24 and 25 for the curtail the right to property and the precedence of DPSP over the fundamental right and the scope of influence review the 39B and C and added to two land reform legislation 9 schedule and line thoughts maintaining strengthening in the subsequent judgment like the Mindra Mill case, SR Bomai case and the Kohlo case. Minerva Mill case, SR Bomai case and Kohlo case. So this is upheld the validity of 24 amendment. Parliament had the power to amend any or all the provision of the constitutional with the amendment should not alter, damage or destroy essential feature of fundamental principle. This came to be known basic structure doctrine corrected the judgment of the Golaknath case. Article 368 contained both the power and the procedure for the amending the constitution and amending power of legislation by Parliament. So Supreme Court upheld the 25 and 29 amendments except parts of curtail its power. Judicial review also asserted the preamble in Parliament. Uniform Civil Code. Recently, Ministry of Law and Justice responded to the PIL in that implementation Uniform Civil Code is matter of the public policy and regard an issue of the courts. Uniform Civil Code provide one law that entirely country applicable to the all religious community. So Constitutional laid out that the state shall endeavour to the secure Uniform Civil Code for the citizens and Indian law to follow the uniform codes in civil matters such as Indian Contract Act 1872. Civil Procedure Codes, Transfer of Property 1882, Partnership Act, Evidence Act. State, however, have made the hundred of amendments for there, and the several states were Government Uniform Motor Vehicle Act and Goa as only Indian states which is follow the community law. Lex Loci reports of the October past the importance of the uniformity in the codification of the law relation to the crime evidence and the contract, but it also recommended that personal law Hindu Muslim should kept outside the codification. Queen 1859's proclamation is promised absolute non-interference in religious matter. B. N. Rao Committee was formed for the codification of the Hindu law and the Hindu Code Bill was R.C. Bhandarkar for the which realized the divorce and the polygamy gave rights to the inheritance to a daughter. Hindu Succession Act amend codification of the relation to instate unwilled successions Hindu, Buddhist, Jain, Sikh and separate personal law for the Muslim, Christian and Parsi. Landmark court was there for Sarla Mudgal case, Daniel Latifi case. Which case? Sarla Mudgal case, Daniel Latifi case, Shah Bano case was there. Now next one is the anti-conversion law. The Karnataka Legislative Assembly passed the Karnataka Right to Freedom Act, which commonly known the anti-conversion. So there's anti-conversion law. Currently there are at least 9 states in the country where legislation on the unlawful conversion are forced: Odisha, Madhya Pradesh, Arunachal Pradesh, Gujarat, Himachal Pradesh, Chhattisgarh, Uttarakhand and Uttar Pradesh. History of the anti-conversion law introduced in the Hindu princely states and to preserve their religion identity from the influence of Christian missionary. Example of Raigad State Conversion Act, the Patna Freedom Religion Act and the Udaipur Anti-Conversion Law. So there is the Raigad, then Patna, then the Udaipur, Patna and Raigad. So Indian Conversion Bill was introduced, Patna, Raigad and the Udaipur, Patna, Raigad, Udaipur. Indian Conversion Bill was introduced in the Backward Community Religion Bill was introduced and freedom of all religion. However, they will be due lack of parliamentary support. So in the law ministry said that the matter purely a state subject and legislature as law by the parliament would not be in accordance with the tenets of the constitution. So this means anti-conversion law are completely in the domain of the states. Register for extraneous laws and the states of Madhya Pradesh. Court upheld the constitutionality of earliest anti-conversion and the Madhya Pradesh of Odisha. Freedom to propagate one religion as a stipulate under Article 25(1) did not grant a fundamental right to convert any person. So this purposely conversion would impede the freedom of the conscience, and it also held the Conversion Act, which is the purview of entry 1 and 2 7 schedule as a avoid the disturbance of public order by prohibiting conversion from one religion to the another, replenish of the conscience of the community. Sarla Mudgal case, Supreme Court held that conversion in Islam was not valid if done only in order to the able practice of polygamy. Lata Singh and States of UP Court highlight the need for the stringent punishment for violence, the threat, intercaste and interfaith marriages. So this is the Lata Singh versus State of UP, and M. Chandra versus the Thanga Muthu another. Supreme Court laid down the, so this is the Lata Singh case, Sarla Mudgal case, and the Chandra versus Thanga Muthu case. This is laid down the conversion first as the conversion for acceptance into the community. Next is official language. So recently Tulu speaker demands that 8 schedules. So Assamese, Oriya, Bengali, Punjabi, 22 languages are there. Part 17 languages are the part 17 of the Constitution. Article 343 to 351 is language are the added to the Constitution amendment. Constitution has the official language different states. So the Article 345 the legislation of the states may law adopt to the more of languages in use to the state or Hindi as a language or the language to be used for all on the official purpose of the states. Recognition of the official language. Sahitya Akademi was started the recognition of the languages. Recognition Indian languages. MP MLA could speak in the language in the Parliament State Assembly. Candidate could write all India competitive exam for civil services. Now cooperatives are the Article 19C and the 43B. Article 19C 43B and the part 4th of the Constitution is shall be endeavor promote voluntary formation, autonomous functioning, democratic control, professional management of cooperative. Part 9B also inserted to deal with the incorporation term of member boards, and it's a Article ZH and ZT. So 9B and ZH and ZT. Cooperative movement was 1844 in Britain. Robert Owen was the Rochable Society equitable pioneer for objective of the society. So this is Sir Frederick Nicholson was known for the father of the cooperative. Who is father of the cooperative is the Frederick Nicholson. So this is studied the problem of father after the Madras Famine published. With name is the Frederick Nicholson. So cooperative fails to state list 7 schedule. Forming cooperative is a fundamental right 97. Constitutional promotion of the cooperative is also constitutional directive to states, and multi-states cooperative will be there to provide registration society with the operation in the then state. So Article 43B is also there, and there is the Supreme Court annulled that the 97 Amendment Act Part 9B of the Constitutional is passed by the Parliament without getting any ratified states. So this court declared the Part 9B of the Constitution to operate only in so far as it's concerned multi-state cooperative society both within various union territory. So this was consumer cooperative, marketing producer cooperative, housing cooperative, and the farming cooperative. Next is overseas citizenship of India. Overseas citizenship plan to the challenge of the Home Ministry notification that require professional of the to notify the about their activity in India. So equate Indian domicile with the foreigner. So exorbitantly high fees under the non-residence of NRI quota cannot be afforded OCI. So Indian domicile students are deprived of the domicile status both in the India as well as country of the citizen. So Indian citizen who is ordinarily residing the outside the India and the whole Indian passport, all benefits available to the Indian citizen subject to notification issued by the government of time. A person is an Indian citizen already. So the OCI is the person registers OCI card holder 7A Citizenship Act in Indian origin but hold foreign passports. So multiple entry lifelong visa for the visiting India for the purpose, exemption from the registration for length of the India, financial, economic, educational field except acquisition, agriculture, farmhouse and the plantation property. They will follow the inheritance, agriculture and plantation property from the person resident in India. Inter-country adoption of the Indian citizen and pushing professional doctor, pharmacist, parity for Indian national airfare and the tariff for the domestic travel in this national park and museum. As per Citizenship Act is for 5 year and ordinarily resident in India for 12 months before making the applications. A person is Indian origin is known as for the part 2 of the Constitution Article 5 to 11 deal with the citizenship of India and provide the acquisition of Indian citizenship. Section 3. Section 4. Registration and naturalization. So prescribe 3 way of the losing Indian citizenship: renunciation, termination, deprivation. Citizenship is a central subject. Ministry of Home Affairs periodically delegate the powers to the state through the Gazette, and this announced the Section 16 of the Citizenship Act, which is received recently. 13 districts, 5 states were empowered to grant citizenship to the certain Afghanistan, Pakistan and the Bangladesh. Now other one is the Constitutional Assembly. So first sitting of the Constitutional Assembly is 75 years. So it's made the first time in the New Delhi, December 9. Central Hall of Parliamentary House Cabinet Mission Plan was comprising the Panthic, Lawrence and Stewart Gibbs and A.V. Alexander created the Cabinet Committee. Is recognized by Section 8 of the Indian Independent Act, and composition was the chosen indirect election of the member of the Provision Legislative Assembly according to the scheme of Cabinet Mission. 292 members were elected through the Provincial Legislative Assembly, 93 members presented to the princely state, and 4th member represented from the Chief Ministry of the province. So this is the result of the partition of Mountbatten Plan. A separate constitutional assembly was set up for Pakistan. Representative of sub-province ceased to be a member assembly as a membership of the assembly was reduced to 99. First sitting was the over Sachidanand Sinha, and 2 year 11 months for the 7-day constitutional. So reservation in the promotion of the person with disability. So this is for the reservation promotion is the for the accordance with the Section 34 of Right of Person with the Disability Act. So this is the person with benchmark disability is not 25 disabilities, and Siddha Raju, States of Karnataka, January judgment, reservation promotion as well as for not just recruitment, and this is the National Federation of the Blind case. So this is also Rajiv Kumar Gupta case is there. Government aid. Supreme Court has Indian right to government aid to the Article 13(2). States that government shall not discriminate anyone in educational institution and while giving the aids, and the constitutional subject to the reasonable restriction for the aided institution. There cannot be any difference between a minority non-minority one institution does not want to accept comply with the condition for the aids. So addition is the Article 1 to 4 is there. Words, sign, invisible representation, non-bailable offence, imprisonment for the life and the imprisonment of the 3 year and fine. Romesh Thapat case and the Kedarnath case and the Kanhaiya case is for redefine the sedition, disruption of the public order, attempt of the violently lawful government and the threatening the security. So this committed a person attempt to bring into the hatred and excited the attempt to excite disaffection toward the government. Hate speech is the Home Ministry's offensing relating to the speech and the expression. No clear definition of the what constitutional is hate speech, and the Indian Penal Codes Committee is home to the criminal law, and this is for the first time is there. So this is for the language, and there denigrate, insult, threaten, targets to the individual base of identify other traits. So the strategy and the plan action on the hate speech which set the strategic guidance for union system and to address the hate speech. So section 124A, 153A and B is for Article 19(2) is or and section 505 IPC's circulation statement 267 reports of the Law Commission is India define the hate speech by mean of race, ethnicity, gender, sexual orientation and religious belief. So this is Vishwananth committee proposed to be inserting the section 153C and section 505A, and this is offense on ground on religion, race, caste, community, sex and the language. Beju Bawra committee is for the pending section 153 and IPC attempting to promote the prejudicial to the human dignity and the punishable 5 year and fine. Both will be the 50A. IPC will be there for punishable 3 year. Sacrilege is the Punjab government writing the assent to the bill that propose the life imprisonment for the dissertation of religion, sculpture of 4 religions. Sacrilege is the blasphemy. This is treating a religion object place without the respect. So this protect the all religion blasphemy law, and the section 295, 295A, 296 of IPC is for the internationally damaged, destroy, define the religious objects. So this is religion in the India, including the 295A dealing with the malleously words spoken and the sign for the replenishment, insult any Prevention of detention. So the Banka Sneha Shivaji states of the Telangana case for the provision of the prevention detention cannot be invoked under apprehension law of the problem. So this is preventive detention action is attained the person taken the ground of suspicion, and this section 151 Criminal Procedure Code 1973 Article 22 provides the protection against the arrest and detention. So criminal section 151 of the Criminal Procedure Act and the Article 22 provides protection against the arrest and the detention in certain case. So this is right aren't granted in the alien or the person detained under the preventive detention law. So this is the Banka Singh case and the Article 22 and the section 151 of the Criminal Procedure Codes is there, and they provide the special protection to the detention, and this is right to granted alien on the person detained the preventive detention. Right to protest is Article 19(1) and B is express their views and assemble together, strengthening holding government accountability, raise the voice against the misuse of power. Absolute right under Article 2 and the 3 is subject to reasonable restriction. Right to forgotten is for the upright. The right to forgotten is right to have a personal information removal, including internet search engine, database, website, and the personal information is for the comes right to privacy. India lacks statutory provision, but the Personal Data Protection Bills 2019 right to erase data and European GDPR Article 17 outline the under which individual can be the right to forgotten. So right to forgotten is that under the right to personal information. Article 311 is for the constitutional is the teacher terminated Jammu Kashmir, and this for the 311 provides that the prior inquiry is required if president or the government is satisfied that the interest of the security of the state is expedited. Foreigner Tribunal Act is for the border state police border wing not to the forwards any against Gurkha, and foreigner tribunal is a quasi judicial body established foreigner order 1964 is or whether its person is foreigner not in accordance with the Foreigner Act. Foreigner Act 1944 empowered the central government to make provision regarding the foreigners, and its set up 1964 unique to the Assam, and the foreigner appreciation by the police illegally prosecuted local courts and the deported put detention center. So this is against the reference has been made the border police, and it's for the doubtful against them. So can be retired judicial official, bureaucrats and lawyer, and minimum 7 years will be the legal practice. Ministry of Home Affairs and the Foreigner Tribunal 1964 empowered the district magistrate to the duty to set up the tribunal to decide whether a person is illegally India's foreigner or not. So Ministry of Home Affairs will be decide, and the case of the retired judicial office, bureaucrats or lawyer will be minimum 7 year legal practice will be there. Earlier power to the foreigner tribunal were vested only to the center, but now state will also there. Foreigner Tribunal Order 1964 to give the opinion whether a person is foreigner or not, and this is Act 1946, and this is unique in the Assam, and there is a two kind of cases like doubtful against them. If there will be a D, and the retired judicial officers, bureaucrat or the lawyers will be minimum 7 year practice will be decide over there. Function of Parliament, State Legislature, Local Government. Declining productivity of the Parliament. So the monsoon session third list of the productive Lok Sabha, and the 8th list produced Rajya Sabha. So this is summoning of the Parliament specify Article 85 of Constitutional Cabinet Committee on Parliamentary and formalize the President MP of summon meet to the session. So this does not have a fixed Parliament, but budget session, monsoon session, winter session, gap between the session and cannot be exist 6 months. So this is the adjournment terminating of the sitting of the Parliament for the few hours. Adjournment sideline terminating of the sitting of Parliament for an indefinite period. The power of the adjournment sideline live is the President Office House. Prorogation end of the sitting as well as the session of the sitting and session both end with the Parliament. Recess is the time between the prorogation and the reassembly. So there is the time between the prorogation and reassembly, that is the recess, prorogation, reassembly. Resolution termination the life of the Lok Sabha. Only the President can dissolve the House. Only President can dissolve the House. Okay. Now Deputy Speaker. Deputy Speaker of Lok Sabha is Delhi High Court is for the Secretary reply to petition on vacant. हाँ ना अरे ना पागल है या वरना यार. Lok Sabha Secretary reply to petition on the vacant post of the Deputy Speaker. The Speaker and Deputy Speaker are presiding officer of the Lok Sabha. Rule of procedure and conduct of business in the Lok Sabha and the Deputy Speakers. Rule 8 of the Rules of the Procedure and Conduct of Business in the Lok Sabha leave to be the Speaker to fix the date for holding the election of the Deputy Speaker. Rule 9 provides for the 10-member panel of the chairperson nominate the speaker to preside over the house of the absence of the speaker and the deputy speaker. They are the group empowered to handle all the duties of deputy speaker. So speaker and deputy speaker are presiding officer of the Lok Sabha while the office of the speaker is vacant or during the absence of the speaker. So duty of the office shall be performed by the deputy speaker. And Article 94 of the Speaker resigned from his office by writing to the Deputy Speaker. Article 93 the Lok Sabha as soon may be choose the two members of the House for the respective Speaker and Deputy Speaker. No timeline on the election by Article 93 President fixed date for the election of the Speaker. The Speaker fixed the date for the Deputy Speaker and since 11 Lok Sabha has been the consensus that the Speaker comes from the ruling party alliance or the post of the Deputy Speaker goes to the main opposition party. Term of the office for the Speaker and Deputy Speaker is 5 years and removal of the Deputy Speaker can be resolution passed by majority of all the member of the Lok Sabha. Deputy Speaker is the chairperson of the Budget Committee and this is Ministry of Finance incorporation of the General Budget. Vice President is the ex officio chairman of the Rajya Sabha. Deputy Chairman is the Rajya Sabha is the constitutional position created by Article 89. Deputy Chairman is the elected from the Amogya Rajya Sabha. Article 178 provides the election of the Speaker and Deputy Speaker and original the institutional Speaker in India. Thus the 1921 where the Central Legislative Assembly was constitutional and Montesquieu Chelmsford reform. Prior to 1921 Governor General of the India and used to the preside over the sitting. Now Public Account Committee, this is estimate committee which is to examine the estimate including budget such as the economic public expenditure. Originally 25 member was there but all of the 30 members was Lok Sabha only. Chairperson of the committee is appointed by the speaker and amongst the member of the invariably by the ruling party. Committee on Public Undertaking was the 1964 recommended Krishna Menon Committee. Is a membership was raised by the 22 and Lok Sabha and Rajya Sabha. So the chairman of committee is appointed by the speaker and amongst the member who are the them Lok Sabha only. And Kaig and Peck, Article 148 provides the independent office of Kaig. He is the head of the Indian Audit and Account, audit reports of the appropriation accounts, audit reports of the finance account, audit reports of the public account. So appropriated finance and public account. President will lay down the reports for the both the House of Parliament. Public Account Committee examined the reports. So this is the oldest parliamentary standing committee on the finance was first constitutional 1921. And this member is 22 members and 15 members for elected Lok Sabha. 7 will be Rajya Sabha. As provide the Indian Act will Montesquieu Chelmsford reform. So speaker is the empowered to the appoint chairman of the committee and speaker is the chairman of the committee. W.M. Halley was the first president and the Bhupendra Nath Mitra is the first president. W. Halley and the Bhupendra Nath Mitra. The last presidents before the independence was the Liaquat Ali Khan. Chairman of the committee belonged to the since 1967 is the convention has developed. Chairman of the committee selected invariably by the opposition. So chairman by the opposition. So the function is the constituted by the parliament each year for the examination of showing appropriation of sum granted to the parliament's finance account of the government of India and other accounts laid before the parliament of the committee. Accounts for the public undertaking and the government companies are which is under the purview of the committee public undertaking. So Parliament Committee is law for the author Article 101 and 115 for the Parliament Authority to make rule for regulating its the procedure of conduct and business. There shall be two type of parliamentary committee, standing committee and the ad hoc committee. Standing committee will be the constitute every year for the periodically and the categorize the financial committee, department standing committee, another standing committee. Ad hoc committee will be ceased to be exist completion of the task assigned. Ad hoc committee can be divided into two category and 17 committees set up to the parliament on the recommendation of the rules committee Lok Sabha and committee will be set up increasing the number of 17 to 24. Department related committee and the examine bills refer to them select the specific topic for the examining this and examining the budget outlay. So there is the 8 worker and the 16 of the Lok Sabha. Rule 268 is total 31 member, 21 from Lok Sabha, 10 from Rajya Sabha is nominated by the speaker and the Lok Sabha on the chairperson of Rajya Sabha. Ministry shall not be a member of the committee but member of the committee shall hold office during not exceeding 1 year. Legislative Council. Cabinet approved approval for the creation of the Legislative Council of West Bengal. Legislative Council is the upper house of the states like Rajya Sabha. Its permanent house, Legislative Council permanent house, nominated by the governor, and his term 6 year. 1/3 of the member will house retire after 2 year. Eligibility criteria will be the 30 year for a person cannot simultaneously be member of the parliament. The Article 169 of the Constitutional Parliament may be law create to abolish the Legislative Council. Legislative Assembly of that states pass resolution to that of affect the special majority 2/3 of the assembly. Article 171 is cannot have the 1/3 of the member. MLA is 2 states, so 40 members. Total member of this states not exceed 1/3 of the total member, and this provides the total number will be there. West Bengal become the 7th Indian states to have a bicameral system of legislation. Andhra Pradesh, Telangana, Bihar, Uttar Pradesh, Maharashtra and Karnataka. So 1/6 will be nominated by governor, 1/3 from legislative assembly, 1/3 from the municipality and the government, and 1/12 from the elected teacher, and 1/12 from the graduates. So this is the basis for comparison. Meaning is like a legislative council is the upper house, and member are partly elected by partly nominated, and the state legislature directly elected people, chairman, and there is the speaker, and there is 30 25. There is the total member assembly 40 minimum 500 and the 60. It cannot introduce, amend, reject bill. It can introduce, amend it, can discuss but cannot vote on demands for the grants, vote on demands on the executive privilege of assembly. It cannot participate. Elected member of the assembly of the states and the union territory of Delhi and Puducherry can participate. Now next one is the Madras Legislative Council. It's 100 year of the establishment for the 1921, which constitute function the Legislative Assembly of the Madras State post 1947, and they set up the Government of India Act. So passed the several landmark registered voting rights for the women. Muthu Lakshmi Reddy, first woman in the council, and the Hindu Religious Endowment Act, abolition of the Devdasi issue for the pattas. So this is the proportion for the election member of the increased over 70%. Concept of diarchy come to be which divided the administrative subject into central and provincial list. Office of the chief minister also can be premier court institutional. One seat for the territorial plural, and the member constituent assembly was reserved for the non-Brahmin. Supreme Court, Office of Profit. So this is the governor can't sit on election commission opinion. Disqualification 12 MLA are usually holding the profits. Manipur has been refined the constitutional or under representation of people acts for different cause interpretation to mean possible certain duty and the public character to allow the legislation to carry out the duty in a manner without any obligation. So Parliament Prevention of Disqualification Acts wide ranging number was there. Article 102 and 191 MLA and MP is the holding under the central states government. Under the article, RPA Act is ground of disqualification. 1964 is the Supreme Court rule that determining whether a person holds a office of profit, and the Pradyut Bardolai Swapna Roy case was there, whether the government exercise control, appointment, removal, performance of function of the office, whether is the remunerative attached to is whether the body in which of the offices held has the government powers releasing money, allotment, land and granting license, whether the office enable holder influence the way of the patronage. So Jaya Bachchan case, Pradyut Bardolai's case is there, Swapna Roy, and the Jaya Bachchan case for the deciding the question to the whether one is the holding an office or profits or not, what is the relevant whether office is the capable yielding profit pecuniary gains and not whether the person actually obtain the monetary gain. So this is two cases are there. Article 102 and 191 MLA where from the office under the central states government. RPA Act will be the ground of disqualification, and this is for the duty of that who has less public character. Next one is the suspension of MP. So the Rajya Sabha suspend entire session. Parliament from the Rajya Sabha member 12 member will be suspended. So rule 256 conduct of the business Lok Sabha, suspension of member from Parliament. The rule has been 13 times in the past suspended 26 member. Rule 256 so for the deemed necessary name as a member who is disregard the authority of the chair of abuse rule. Council of persistently and willfully obstructing the business thereof. Members so named the suspend for a period of exceeding remember for the session. So the council may be time on the motion being made and resolve the suspension termination. Expansion of the Council of Ministries. So Union government have expanded the Council of Ministries 77 by introducing new ministry. 91 amendment of the Article 71 is for the Union Council of Ministry cannot exceed more than 15%, and ministry is constitutional body, and this is classification of the three-tier body: cabinet, states, and deputy ministers. Rajya Sabha Constitutional Schedule Tribes Order Act. So there is the part 17 of the schedule to the constitutional of the order. This delegation of above inclusion of the Mishmi, Kumam, Iddu, and the Tarao, Monpa, Memba, Satrang, Sartang, Sajolang, Momba empower the president to specify scheduled tribes and permits the parliament to modify the scheduled tribe. Repealing the law. Government recently announced the three contention for the law. Article 245 constitutes that the parliament has power to make the law, given the power for the parliament to repeal through the repealing amending act. So usually bill title the repealing of the amendment was introduced. It was passed through the same for the bill. This is the parliament repealed 50 odd obsolete law, and sunset clause was there. For sunset clause, parliament did, which is then exits, and this anti-terror legislation and disruptive activity, commonly known the TADA, and the allowed to be the lapse 1995. Center state relation, interstate river dispute. Ministry of Jal Shakti, Godavari River Management Board, Krishna River Management Board, Andhra Pradesh Reorganization Act was the constitutional provision for the inter-river disputes. So Ravi, Byas, Satluj, Narmada, Mandal, Mandovi, and the Madhavi, Krishna, Periyar, Godavari, Kaveri, and the Vamsadhara. So this is the entry 17 of the state list deal with the water supply, irrigation, drainage, and embankment water storage. Entry 56 gives the power to the regulation development of the interstate river valley. Article 262 provides the adjudication of dispute of complaint relating to the water interstates, and this is the neither the Supreme Court nor any court will be jurisdiction. So River Board Act 1956 for establishment River Board regulation and development interstate river and river valley establishment central government. So Interstate Water Dispute Act and the decision tribunal is final and also binding. Is final and binding. The chairperson and the member of the water dispute tribunal are nominated by the Chief Justice of India. So doctrine of riparian right is emphasizes the recognition equal rights for the water by the owner and land abutting river. Theory of the absolute territory and sovereignty human doctrine is there. Theory of prior appropriation, which is the parter beneficial for establish the prior rights and the subsequent operations for this. Theory of the community interest is there, passing the thought several states, and this is doctrine of equitable appointments. The interstate water disputes is for the equality right determination. The equal is for the encompasses social economic needs. Doctrine of widely been India and stand judgment of the Indus Commission, Krishna Water Dispute Tribunal, and Narmada Water Dispute Tribunal. Theory of the equitable utilization of interstate water. Helsinki rules and the composite rules will be there for the water. Berlin rules are also there for provide the basin for states should be managed according to the international drainage. So interstate water disputes was passed by the Lok Sabha seek to the replace the dispute settlement mechanism under the setting up the dispute resolution committee. Interstate border dispute India Meghalaya was the carved Assam full-fledged states 884 border. There will be 12 point of dispute between the two states including the Langpi, Boko, and the Kamrup, and the Metropolitan and the Hailakandi districts. Disputes stems to the from Meghalaya and government refusal to accept the Assam Reorganization Acts and the Social Regional Committee. So Himachal Pradesh Ladakh is for the lying for the Leh and Mahanadi river. Haryana, Himachal Pradesh, Gujarat, Rajasthan, Odisha, West Bengal, and the Kanika and the Sandhya Islands. Haryana, Punjab, and the Maharashtra, Karnataka, Belgaum district, which is the large Marathi speaking population. Karnataka and the Kerala, Kasargod part of the Kerala, Marathi speaking in the Maharashtra. Odia is for the along with the mainland boundary of the Kanika Sand is island of Bay of Bengal. Haryana and Himachal Pradesh is the Parvau region of the Parikulla. Gujarat and the Rajasthan is the Mangad Hill. Himachal Pradesh and the Ladakh is for the Sachu and the lying along with the Leh and the Manali highway. Haryana and the Punjab for the Chandigarh. So Assam Reorganization Act 1969, Special Region Committee for both the states resolved the issue. One of the oldest, greatest civilization of the world, the present day for the Union was formed to be 550 princely states and British territory. The States Reorganization Commission divided the territory 14 states, 6 Union territory. So today, through the subsequent organization, the total number of administration division of 28 states and UT. This division will be create the border. Seventh schedule of the 15th Finance Commission chairman has called the seventh schedule constitution in the wake of the current challenge. Article 246 of the Parliament is states for the seventh schedule broadly national importance of the allocation of the union and entered the local concern were allocated to the states. Reason behind the list was unity, integrity of India, cooperative federalism, provision, autonomy, balance, economic development, enabling the respective governments. So there is the list one. List one is for the defense, foreign affairs, railway, banking, and list two public order, police, health, sanitation, and the gambling. List third is the education, population control, family planning, criminal law, protection of wildlife, animal, and the forest. For this, so borrowing power of the state government. So last year the central government increased the borrowing power of the state government. So this is the 3% of the GDP and 5% of 1% raised to link to the showing progress of the four sets of reform measures: one nation, one ration card, ease of doing business, power distribution, urban local body ceases for the adopt the progressive policy to avail the addition fund. 20 states avail the additional borrowing 1.06 crore. Fiscal this FRBM Act 2003 Act provides for the deviation from the annual fiscal deficits and targeted 6.8% of the GDP. Government aim to steadily reduce the fiscal deficit 4.5% of GDP. So constitutional provision is the under the Article 292. This power is limited act for the state legislation. So this is for the unrestricted power to borrow subject in limit parliament. No restriction can borrow domestically and from abroad can only be raised the loan domestically, and the other restriction can borrow upon the security of consolidated fund of India under the 293. State can't raise a borrowing with the center consent, and if it's say any load outstanding which is repayable to the government of India. Special category status. Special category measured the extent to the Andhra Pradesh and lieu of special category. So this provide the way of the loan interest extended aided to the projects and dispersed there. So this first is for the classification given to the center to assist development of the state. Geographical and socio-economic development, hilly terrain, strategic, international border, economic infrastructure, backwardness, non-viable to the finance. 14th Finance Commission was SC only to the northeastern and the hilly states. Central government has 90% states expenditure, all centrally sponsored scheme, and 10% given to the states for the 0%. Next is inner line permit. And Ladakh administration has scrapped the inner line permit for the all Indian nations visit the protected area, boost the rural tourism and underline the sovereignty. So foreigner intending to the visit the protected area need to be permits. Protected area permit validity for the extended 7-day and 15 is official document issued by the state government that allow the Indian citizen travel to the states under ILP, and the system is to forward the today northeastern Arunachal Pradesh, Nagaland, Manipur, Mizoram indigenous community in the northeast regulate the monitor and the movement to the certain area near to the international border. Concept of Bengal Eastern Frontier Regulation, which where the British framed regulation restricted the entry of the regulation to the stay outside the designated area. So this protect the crown or commercial interest, preventing the British subjects from the trading within the region. So Arunachal Pradesh, Nagaland, Manipur and Mizoram is there. Four eastern states are there: Arunachal Pradesh, Nagaland, Manipur and Mizoram, and this protect the indigenous community in the northeast. Arunachal Pradesh, Nagaland, Manipur, Mizoram. Arunachal Pradesh, Nagaland, Manipur and Mizoram. Okay, so these are okay. Formation of new districts. So Punjab government created Maler-Kotla as the 23rd district. Maler-Kotla. So this is the create new districts, alter the abolish existing districts. State government this through the executive order of the, and when a states want to the change the name of the district's railway station, it require a no objection certificates of the number. So it's for the Ministry of Earth and Intelligence Bureau. Formation of new states are union government to create a new states and reorganization of the states. The basis of reorganization could be linguistic, religious, ethical. Article 234 for the constitutional regard to precedent reference, and the parliament is not bound to accept or upon the state legislation, but it's a amendment 268 will be there. Now, sixth schedule is the demanding that the region is included in the sixth schedule. So, sixth schedule is covered to the administration tribal area states of Assam, Meghalaya, Tripura, Mizoram, and this allow the constitutional autonomous district council autonomy to provision to the safeguard of land, employment, and cultural identity. Appointment of Director General of the Police. This is set up the National Security Commission and constitute the State Security Commission. Fixed 2 years tenure for the DGP, 2-year term for the SP and SHO. Separate investigation and the LO functions. Set up the Police Establishment Board. Set up the Police Complaints Authority. The Supreme Court refused to certain applications but appoint is Director General of Police without any public service. This is the police is the state subject and a landmark Judge Prakash Singh judgment, and the state needs to the seats name for the DGP and the UPSC, which will pick the candidate from the eligible name based on experience and sincerity. They select any of the top 3 candidates provided to the candidate minimum 6 months and left. Prakash Singh Badal and Union of India case for the political lack of accountability, weakness, poor round performance will be there. Section 51 of the Disaster Management Act is saved to the show cause of the notice Union Home Ministry. Disaster Management Act's a punishment for the obstruction to refusal of directions on behalf of the central government. State government is National Executive Committee. The State Executive Committee will be there. District level committee. So district level committee, Ministry of Power oversee all the power related scheme. Committee will comprise the member of the Parliament, district chairperson under the MP and the district corporate chairperson, district collector. So this is the states and UT notify the district electricity committee and ensure the involvement of the oversee the people. The Deen Dayal Upadhyay Gram Jyoti Yojana integrated power development scheme, Pradhan Mantri Sahaj Bijli Har Ghar Yojana, revamp the distribution sector and improving the operational efficiency, financial sustainability, DISCOM. Next is the judiciary, rule of law. So it's for the ensure constitutionalism, ensure social justice, preserve democracy, constrain arbitrary power, and protection of the fundamental right and human rights. So story of rule of law is nothing but the story of civilization of the human. A.V. Dicey, rule of law means the absolute supremacy of predominance of the regular law oppose the influence of the arbitrary power, and this is governed by the imbibing the ideal of justice, equality, rule of law. Rule of law is for the ancient Roman during the formation of the republics is medieval Europe, and Hobbes and John Locke, Rousseau is there. For the Indian philosopher Chanakya have also imposed the rule of law and government not only the nominated represented people, but this rule of law have been derived from the French phrase of principle of legality, government based on the principle of law. So this rule of law is control the unlimited power for the supreme law authority. So rule of law is laid down the supreme lawmaking, and rule of law upheld the guidance to the like justice, equality, and Article 14 of Constitutional shall be the equality before law, equal protection of law, and the guide religious, race, caste, sex. So no man punishable except for the district of the law. No man is above the law, and constitutional result is right of the individual. Define the enforced court of law. The law must be the clear and accessible, simple, ambiguous. Equality before law, justice before rule of law, right to participate and creation of the refinements of law, strong independent judiciary will be there. Rule of law is the basic structure, supremacy of constitutional. Article 30 provides judicial review. Article 14 equality before law and equal protection of law. Article 21 no arbitrary actions will be there. Article 50 provides the separation power of legislative, executive, judiciary and independent judiciary. So article this is a foundational pillar for the embedded in the constitution. Contempt of the court. So article 261 is full faith of credit shall be given to judicial proceeding. Article 9 is reasonable restriction. Article 129 214 is for the supremacy and power to punish a contempt respectively. 142 is power to Supreme Court punish the contempt is for the Supreme Court for the contempt. Article 142, 129 and 214, and the Contempt of Courts Act is to define the contempt of court. Constitutional not define it. Civil contempt for the disobedience of the order. Criminal contempt for the scandalization of the courts, and this to interfere the judicial proceeding. 6 month imprisonment, 2000 fine, and the cannot initiated contempt proceeding pose 1 year expiry or list contempt. So fair and accurate reporting will be judicial proceeding. Fair criticism of the merit and the defamatory attacks of the judge and not attained to the proceeding. Amended the introduction of the truth as a valid defense of the public interest. So this is the article 214 and 129 is for the constitutional power which cannot be abridged or taken away, even the legislative enactments. So article 1242 is provision for lawmaking legislation enactments, and article 129 also appointment of judges. Center approved the Supreme Court for collegium for the appointments of judges. So last 71 years Supreme Court has appointed only 8 women judges, starting from the Fatima Bibi and Justice Indira Banerjee, long serving. Fatima Bibi and the Indira Banerjee for this top courts by the elevation of the courts. Article 124 and the 214 Constitution governed by the Supreme Courts, and President has the power to make appointments after consultation such judge of Supreme Courts and High Court states precedents deemed necessary. 3 judges are there. Supreme Court involved the collegium system, and this committee was the senior judge and the Supreme Court member of High Court. So central government was make the appointments of 3 to 4 weeks, and this government are the recommendation if again the government bounds. Average sex ratio will be the 88 males and 12 females, and the average sex ratio in the judge lower judiciary is 28 male and females are 28 female, males are 72. Recently, Madras High Court Chief Justice transferred the Meghalaya High Court, and this Article 22 provide the transfer of judges and the High Court to any High Court. So, initiation of proposal transfer of judges should be met CJI, whose opinion is regard to be determined. Consent of judges for this is first, subsequent transfer would not be required. Constitutional did not mention the ground of procedure which is power to exerted, but power to select, appoint, transfer of judges is Supreme Court. 3 judge case is such judgment required transfer. Transfer of judges cannot be punitive measure but public interest and better administration of justice. Concurrence of CJI, effective consultation. Appointment of judges at district level. So, central government preparing the give to the fresh push to the establishment All India Judicial Service. Reform of the justice by the centralizing recruitment. This is the article 233 and 234 Constitution of India deal with the appointment of district judges. Conducted the State Public Service Commission and concerned High Courts, judiciary of states panel, High Court judge interview the candidates, and judiciary up to the level district judges. So, provision for the civil service exam, for commonly referred to the judicial service exam. Reforms in judiciary by the centralizing and recruitment of judges, district judges are there. For the Union Public Service Commission conduct the central recruitment process and allotment of success candidate. So, 14 Finance Commission of 1958 reports reform judicial administration, and the 42 Constitutional Amendment Article 312 All India Service include the All India Judicial Service, ensure uniformity in the standard of selection, attract the bright young talent, and the speedy justice made available to the every citizen. Parliament Standing Committee Personal Public Grievance, Law and Justice 15 report to the Pan India Judicial Service. All India Judge Association will be there for the Justice Shetty Committee, and this central selection mechanism. Tribunals are there for the past tribunal reforms, rationalization of the quasi-judicial body, and the neither courts nor the executive body, guided by the principle of natural justice power of the civil court, inserted into the 42 Constitutional Amendment adding to the 323A and B administrative tribunal and for the other matters. So this is the act dissolves certain existing appellate body, various act and transfer of function, cinematography act, copyright act, custom acts, airport authority India, trade act. So this is judiciary article 14 and separation of power, and Supreme Court section 148 of Financial Act is there. So act specified that a person should be at least 50 years of eligible for appointment of chairperson. Mediation Act bill is recently introduced Rajya Sabha and referred to the standing committee, seek to promote the facilitate mediations, especially institutional of mediation for resolution disputes, commercial otherwise, and for mediated settlement. So its promise effective dispute resolution of ease of doing business. There is no comprehensive government for ADR, but establishment mediation council, mandatory pre-litigations, due recognition, online mediation, provides for the commonly mediation period of 180 days for the completion of mediations and mediation fund. ADR is alternative dispute resolution system, typically include early, neutral, evaluation, negotiation, counseling and mediations. Arbitration is the procedure which is dispute submitted agreements of the party to one of the more arbitrator make the binding decision. Conciliation is the voluntary, flexible, confidential, interest-free process which is parties seek to reach the amicable dispute settlement settlement assistant neutral third party known to the conciliator. Dispute party will ask the conciliator to provide them with non-binding settlements. Mediation is the procedure in which a neutral intermediary, the mediator, helps the party each a mutually satisfactory settlement, and the settlement is then recorded to in the enforcement court, and as a measure of the principle, mediator will refrain from the making the non-binding settlements. Okay, related news are the Chief Justice of India released the vision and the mission statement for the National Legal Service Authority Legal Service Act. NALSA constitute under the Legal Service Constitutional Act. Legal Service Weaker Lok Adalat will be there. For the Article 339A will be the 42th amendment. Direct the state to provide free legal aids and suitable legislation scheme. So the Parliament passed Legal Service Authority Act, and one of the alternative dispute redressal mechanism dispute case will be the law of the pre-litigation state. Statutory status will be there, and award for the deemed to be decree of the civil courts and final and the binding in the all the parties. So no court of fee payable in the Lok Adalat. Okay, so Lok Adalat are final and binding. No court fees are there. Pre-litigation law will be there. Dispute pending. Statutory law will be there, and no jurisdiction to decide matter of merits. Return the case to the courts from which of reference has been women, children, SC, ST inclusion of person eligible for the free legal aids are victim of trafficking, this personal custody, and this all. So there is the United Nations Convention International Settlement Agreement resulting from the Singapore Convention. Mediation has into force into India signing the convention. India Singapore Mediation Summit addressing the summits and presiding mediations for the first step. UN Treaty to the name Singapore Instrument facilitate international trades and promotion of mediation, expected to bring certainly stability to the international framework for mediations. Non-sustainable development goals, peace, justice, strong distribution. Court referred the mediation for the Court of Civil Procedure and Mediation Conciliation Project Committee will establish for this, and private mediations qualified person will also be there. Judicial infrastructure and in India. So Chief Justice of India has proposed National Judicial Infrastructure Authority of India. This is the budgeting and the infrastructure development subordinate court. So key is for the National Legal Service Authority Act, central agency, states agency having a judicial infrastructure. NALSA provides for the weaker section and the place under the NJAI. Chief Justice India would be the patron of in Chief Supreme Court of India. It would be the few High Court judge as member and such central judge. So e-court mission will be there for ICT scheme for the special courts, and the launch the Gram Nyayalaya online portal, and the data government's quality index will be there. Centrally sponsored scheme for the development infrastructure. So assist the state government in constitutional court building. Judicial officer will be there, and extended to scheme for the periods of 2026 for include fund implementation Gram Nyayalaya scheme, and the judicial delivery of the legal reforms establishment, and the Gram Nyayalaya Act speedy easy access to the justice, and it's for the justice by the reducing the delay area in the program. Live streaming of the court's case. E-committee will be the draft model rule for the live streaming of the court case. Swapnil Tripathi, Supreme Court is for the right to assess the justice under Article 21, publishing court's proceeding of the Article 129, and this is for the sexual offense, gender violence will not be there. Delay in the 10 minutes streaming. Unauthorized streaming will be not there. SUPAS is for the Supreme Court portal for assisting the court, effective AI-based tool for the collect the information. SUAS is for the neutral transaction AI-based tool for the judgment. E-court mission is for the vision to the judiciary. Fast and secure transmission electronic records. Faster system is for the wait for the day to end of behind released because of the certified hard copy. Next is the power of the court under the Schedule Caste and Schedule Tribe Prevention Atrocity Act. So power of Article 142 and Section 482 is for the Supreme Court by the orders Section 484(2), whereas its primarily private civil nature has not been committed to the caste of victim, whereas the constitutional legal proceeding and satisfy underlying the would be convened there. So the prohibit the commission offence against SC, ST and nullify the controversial Supreme Court stringent action. National Courts for Appeal. Attorney General of India for the National Courts for Appeal is the occasion of Constitutional Day. 229 reports for the Law Commission and the Supreme Court 1986 is intermediate appeal courts between the states high courts and the Supreme Court's 15 judge. So this dealing with the appeals of deciding the high courts at tribunals, and it will be the final and required to the constitutional amendment. National litigation policy. Government recently under consideration guideline for prevention, controlling, reducing litigations. So this is for the aim to transform the government into the efficient and the responsible litigations. So policy will be have the enabling the pending cases reduce the 15 to 3 year. Step will be reduced litigation amicable mechanism for the resolutions, and this will be the pre-litigation settlement will be there, and the legal litigation will be there. Tele law. So this is tele law mobile app, Ministry of Law and Justice pre-litigation optimize the citizen centric justice technology to connect the beneficiary with lawyer. Martial rape upheld the marital rape although not penalties. India good ground is claimed to the divorce. Kerala High Court. For this, Indian Penal Code is for the sexual intercourse. 15 year will be the section 375 definition of rape and thus immunized act of the prosecution. So India is the one of the 36 country. Martial rape is not legal crime, but martial rape is not the legal crime, but legal provision is 498A deal with the subjected to cruelty husband and any relative husband. Domestic Violence Act 2005 recognize the punishable under the Indian law, and this is criminal act of the rape of the wife and the man. Mercy killing. For the mercy killing applicable 9-year-old raised to the Andhra Pradesh court. Euthanasia's mercy killing refer to the act penalizing the person for the death of the person. So the Gyancore states of Punjab with euthanasia for the Article 21 right to die. So overruled the Rathinam Union of India case and the section 309 Indian Penal Code. Arun Shahbag Union of India case is that passive euthanasia could be given, and common case Union of India upheld the fundamental rights and life and dignity. So this is for the active euthanasia, killing patients. Active means example of injecting patient with the dose of drugs. Election law and the amendment bill. Election is the article fundamental law is there. Representation of People Act is there, and this is the allocation of seat delimitation. Constitution election to the House of People and legislative states. Qualification of voters such as election and preparation of election roll. Conduct the elections House of Parliament and House of Legislative. Qualification, disqualification, corrupt practice. So linking to the electoral roll with the Aadhaar and section 23. Person may apply to the electoral registrar office, and its office is satisfied applicant is entitled to registration. Direct the application name of include the electoral roll. May be required the person to furnish the Aadhaar number, and the authentication will be there. So this is unable to furnish a Aadhaar number suffice to the clause. May be permitted to the furnish alternate document prescribing by the central government. Qualification date of the enrollment in enrollment section 14 of the RPA Act is qualifying date enrollment January 1, and January 1 can be enrolled for this preparing to the next year. So this is for qualifying dates, and January 1, July 1. Gender neutral provision section 20 and for section 60. So ordinary resident and constituency registered electoral roll. Service qualifications such as the armed force and the central government and the deemed to be qualifying. So this is section 1951 qualification of the person postal ballot. This is wife and spouse act requiring premises election purpose. Polling station for the storing ballot box. Expand the purpose and the counting storage and voting machine, and this wall of electoral are the basis of the part 15 324 to 329 elections is there. Universal adult franchise, no discrimination ground or religion, race and the caste. Provision for reservation of seats scheduled castes and scheduled tribes, and the delimitation commission will be areas of boundaries of the election, and the number of constituents will be changed to up to 2026. Voting takes place the first post pass system Lok Sabha election and to the parliamentary representation and the Rajya Sabha election. Political party are indispensable part of the electoral process. Election commission has enhanced the existing elections, and this is the reason city for substantial increase the elections and the cost of inflations. Expenditure of the Lok Sabha for the from 1795 biggest assembly constituency will be there, and this is the move to the following election commission to postpone the election in view Guru Ravidas Jayanti celebration. 153 representation of people extend to the time of completion election. Such extension should not go beyond the normal dissolutions, but term of the house can only be extended emergency, and constitutional restrict the emergency. Anti-defection law. This is given the West Bengal Speaker deadline to pass order the defection case, practice of floor crossing one political outfit to another. So, for instance, the Lok Sabha MP party A to B so defected will be thus face the prevalent anti-defection proceeding. 10 schedule of 52 constitutional amendment on ground of defection, disqualification, voluntary give up membership, voter abstain from the voting in the such a house contrary to any direction issue. Political party without obtaining the permission of the party such as not been condoned to the party 15 days. An independent member of the house can be disqualified to remain a member of the house if he joins the political party of such an election. A nominated member of the house becomes disqualified for being a member of the house if he joins any other political party expiry of 6 months. An exemption legislation may change the party without risk of disqualification, allow a party to merge into the another party. 2/3 of merger will be there. Is elected a speaker, Lok Sabha or the chairperson, then could resign from the party and rejoin the party. And it must be noted here the provision of the 10th schedule pertaining exemption from the disqualifications legislation 91 constitutional amendment deciding authority any person regarding the disqualification decided by the presiding officer. Rule making power will the presiding officer of houses empowered give effect to the 10th schedule. So, how has been interpreted court while deciding related matters? Interpretation of the phrase voluntary gives of membership, wider connotation of the resignation, interpreted the absence of formal resignations and membership inferred to the conduct member who has the publicly expressed opposition to their party and deemed to have the resigned. Decision of presiding officer is the judicial review will be there, then subject to judicial review. This condition struck down the Supreme Court of Kyoto Hohoken and thereby the appeal against the presiding officer decision in High Courts of Supreme Court. So it held the judicial interpretation until presiding officer give its order. Time will be presiding officer has decided and this unnecessarily delay of deciding such petition will be direct speaker to rule the disqualifications and do not within the reasonable time. Electoral bonds are the electoral and interest-free financial instruction making the anonymous donation. A citizen of the India body incorporated the country 1,000, 10,000, 1 lakh will be the SBI and where maybe the bond be both 10 days in January, April, July, October redeemed to be the design accounts of the registers political party 15 days which a political party are eligible to receive the donation through the electoral bond. Political party who have at least the 1% of votes in the Lok Sabha or State Assembly election 29A of the Representation of People Act and its announced electoral bond scheme which is the budget of 1978 and there is no limit for the number of bonds individual but SBI deposit bonds that is political party has enacted 15 days in the Prime Minister Relief Fund. Other important news electoral voting machine it's for the VVPAT EEM is a microcontroller based portable instrument which modernizes election procedure and conducting the election. EVM is a control unit, balloting units and together to wire cable. EVM do not require electricity and run the ordinary battery but EVM first use the Parur assembly of the Kerala and section 61A of the Representation of People Act record to the maximum 2000 votes. Maximum 64 candidates of the nota alphabetical order will be candidate national political party and this is the voter verified audit trail will be independent machine to help the voter verifying the vote. Slip will be printed to contain the number, name and symbols and printed slip will automatically fall to the box. Model Code of Conduct is guideline issued by the Election Commission involved to the consensus of political party. So this Article 324 of Constitutional Election Commission power of the this is Parliament operation from the date of the election schedule and announcement is introduced the States Assembly of Kerala and Election Commission issued the Code of Conduct. So its certain provision will be there for involving the corresponding provision and Indian Penal Codes and Code of Criminal Procedures will be there. Star campaigner status. So Supreme Court state the Election Commission order revoking the campaign status in this is for the Madhya Pradesh State Assembly. So feel to be the poll no law governing which is cannot be made in the campaigner. So recognizing political party can foray the campaigners stars recognizing the political party as per the revised guidelines of the pandemic maximum limits all the number staff campaigner will be the 30 and 40 star 15 in the place of 20 during the periods of pandemic communicated to the Chief Election Commissioner Election Commission. Delimitation Commission Act. So constituted to the redraw the constitutional Jammu Kashmir, Assam, Arunachal Pradesh, Manipur, Nagaland process fixing the boundary of the territorial constituency. Delimitation assign the high power of body Supreme DC of the Boundary Commission. So Article 82 of Parliament Delimitation Act under the Articles 170 and the Constitution 4 1952. These are appointed the President in order to have a law and cannot be challenged on the court. So serving the retired judge of Supreme Court, Chief Election Commission and the Election Commission. Central Vista project is for the new triangular Parliament building command to the Secretary Central Command Office along with the Prime Minister Office residential and the protected group of building Vice President Enclave needs to project due to the increased population which is the quadrilateral independence and this increase the through the current parliament. Floating constituency. Kashmiri Pandit organized the floating constituency reserved for contesting voting. Only the Kashmiri Pandit migrate Jammu Kashmir and this only floating constituency is the Sangha model of the Lamba Sangha in Sikkim and constituency without geographical boundaries. One Nation One Legislature portal is All India Presiding Officer Conference EPOC is One Nation One legislation for the apex body legislative of India and women right to the women will be there. Next is important legislative bill. Panchayat extension to the schedule area bill. It's a national conference organized to the 25 enactment of PESA Act. PESA Act for the Article 243 MS exempt to the 5th schedule and the 9th provision for the Panchayati Raj Parliament and power to the extend the provision for scheduled caste, scheduled tribes is PESA Act. Dilip Singh Burriga Committee. So this PESA Act for the constitutional within the constitutional part 9 of the constitutional 5th schedule and this 224 is the modification that Andhra Pradesh, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Madhya Pradesh and this recognize the role of Gram Sabha authority directed to the Gram Sabha and Panchayat Ministry of Implementation, Ministry of Panchayati Raj will be there and this for the traditional management and the social religious practice. Separate Gram Sabha will be there for safeguarding, preserving traditional custom and the cultural identity, community resources, customary mode and reservation for the seats minimum 50% for the panchayats and the ST for role of responsibility Gram Sabha to approve all development of the village and identifying the beneficiary. So this was the power of the mandatory consultation matter. Land acquisition prevent the alienation of the land, resettlement and the rehabilitation of prospect of the licensing and lease of the minor producers, regulate the consumption liquor and management of the markets, to manage the minor water bodies and the ownership of minor water produce, control the institution and the functioning of the social sector in the local area. Forest Right Act. Forest Right Act is the Ministry of Environment. Forest is Ministry of Tribal Affairs jointly for the expedition, implementation and tribes and the traditional forest dweller. Commonly known the Forest Right Act is strengthening the conserving the regime of the forest maintenance under the historical injustice will be dwelling and tenure livelihood and food security forest dwelling for this. So this is the forest dwelling schedule tribes and traditional who have residing to the forest. The title will be the forest right to ownership of the tribal forest dweller, right to minor forest produce, grazing and fishing, to rehabilitate the illegal eviction, displacement, development of purpose, infrastructure, needs of community. Forest management right will be there to resource and have been traditionally protecting the conserving the suitable. Knowledge right to intellectual property and the knowledge recognizing traditional customary right. Gram Sabha is the authority to initiate the process and this individual right will be the community forest rights will be there. Community forest rights for the land of traditional customary boundary, village and seasonal use for the landscape. For this is for the forest, protected forest and such. Minor forest produce is for the plant including the bamboo, brush, wood stems and the cane, tussar and cocoon. Forest dwelling scheduled tribes are for the land for depends on the forest. For the land bona livelihood needs to be included. Other traditional forest dwellers is for at least generation of 10th and primarily reside to depend on the forest. Critical wildlife habitats, national parks, sanctuaries, Ministry of Environment, Forest, Climate Change Conservation and the forest village are there for the establishment inside the forest and the state's government will be the determining. Juvenile Justice Care and the Protection Children Act is for the Juvenile Justice 2015. So amendment 2021 juvenile justice are the 18 age general conflict law. Children need to be the care of the protection and the trial of the juvenile conflict age of 16 to 18. Replace the juvenile delinquency law and juvenile justice for this United Nations Convention of the Fight Against the Child Hague Convention and the corporate respect to the inter-country adoptions will be there. Adoption is a child final once a civil court adoption order. So district magistrate, including the additional district magistrates, is speedy disposal of effectively coordinate to the monitor function of various agencies, supervise the district child protection, special juvenile protect. Appeal will be no appeal for the order of child welfare committee conducting that person is not a child in needs of care or protection but agreed to adoption order. Appeal before the divisional commissioner 13 days should be disposed within the 4 weeks. Now offense committed juvenile, heinous offense will be the minimum punishment will be there, and serious offense will be there 7 year, petty offense will be there 3 years. So the justice board inquire into the child and their minimum imprisonment 3 to 7, maximum 7 on above. Give effect to recommendation of Supreme Court Shilpa Mittal and the NCT Delhi. Provides the all offense of will be tried to the children of the courts. The offense will be the children that will be the punishable improvement. So the 7 year will be the children courts equivalent to the courts. So this is punishable imprisonment 7 year and tried to judicial magistrate. Offense will be imprisonment between the 7 years and cognizable offense such as the non-cognizable, non-bailable offense will also be there. So provides offense will be tried to the children courts or non-offense, cognizable, non-bailable, and this is states constitute one more for the districts. Certain criteria for the appointments will be there. So welfare of the children, dignity, degree of the psychology, psychiatric law. So traditional criteria will be has any past record of violation of human right and convicted offense, moral turpitude, removal of the dismissal from the service. State government and the undertaking corporate on to control by the government of India, state government. Child abuse and the child labor, moral act, management of child care institution. Cable television network amendment rule, it provides the statutory mechanism to redress the citizen grievance relating to the broadcast television channel. Cable television network regulation is institutional mechanism. Interministerial committee for does not have statutory backing. It in interministerial committee, no statutory backing is there. 3-level grievance redressal mechanism will be there. Draft cinematography act for the Ministry of Information and Broadcasting. Cinematography bill, process of certifying the film theatrical release and the effective for the subcategorization, viewing the classification. Cinematography provides the certification of films under 3 category. Penalty will be film privacy and the jail term will be fine. A grant will be for the High Court Mumbai 9 regional office will be statutory body section 3 and its cinematographic guidings for the section will be film public expenditure. Direct to the modification. Model Tenancy Act is for the bridge the deficit between the tenants and landowner. Tenancy agreement, no person will let out the premise of the such security deposit will be the maximum 2 months and the rent authority will be appointed district collector and rent of the rent tribunal will be for the set of districts and withholding the essential supply. Narcotics, Drugs and Psychotropic Substance Amendment Act, this is for the act accurate certain operations and this is the financing certain illicit activity, punishable rigorous imprisonment of the 10 year and this for the retrospective. National Anti-Doping Bill, for this statutory framework for the National Anti-Doping Agency, National Dope Testing Laboratory will be the NADA and establishing the Society Registration Act. NADA is the investigating, levying sanctions and rules, power of the inspection, simple coercion and sharing the free flow of information. National Board for Anti-Doping is a board agency of the anti-doping. This doping represent the substrate of psychological mediators. Anomaly, human body introduce the extent aid to the increase the athletes. Now next is Khasi Hill Autonomous Districts Inheritance Property. Introduce Khasi Hill Autonomous District Council for the 6th schedule. Distribution of parallel property of the siblings. So this is the Khasi of matrimonial society. Younger daughter inheriting the property right to passing districts court. Central University Act is for this amend the Central University Act Ladakh. And women right in the inherited property. This is the right to women. Dowry Prohibition Act, Succession Act and the Hindu succession for the right to inheritance of Hindu joint family. It amend for the first time for the Hindu female become the absolute owner. The Hage and the Shri Dhanam is the defined Dowry Prohibition Act. improvement constitutional statutory execution of the body. CBI and ED, Central Ordinance for CBI and ED is for the Delhi Special Police System. Ministry of Personal Public Grievance is the CBI recommend for the Santhanam Committee and provide the Assistant Vigilance Commission for the nodal agency in the coordinate investigation behalf of Interpol. So this is the main investigation agency central government relating to the corruption and major criminal cases. Is a non and statutory body. It's a not a statutory body. Bas Lokpal, as prescribed, the CBI director shall be appointed. The recommendation of committee comprises the Prime Minister, leader of opposition, Chief Justice of India, and the Judge of Supreme Court. So, central government can be authorized CBI to investigate such crime states only with the consent of the concerned states. Supreme Court, High Courts, and however can be the CBI investigation crime anywhere. So, this Law Enforcement Economic Intelligence Unit will be there. From the Foreign Exchange Regulation Act is there for the Department of Economic Affairs Enforcement Unit. It was renamed the Enforcement Director, administered by the Department of Revenue under the Ministry of Finance. So, Foreign Exchange Management Act, FEMA and FERA. Press Council of India as Press Council of Association will be there to the autonomous statutory quasi-judicial body under the Press Council Act. So, moral watchdog of the Indian press, composition, chairperson, 25 member. 3-year for this will be National Commission for the Safai Karmachari. Cabinet approved the extension of tenure for the National Karmachari is 3 year beyond, so it's for the later validity will be extended and the tenure will be extended to the non-statutory body. And this recommendation government regarding to the program for the welfare of Safai Karmi, monitoring the prohibition, employment, manure scavenger and rehabilitation. National Backward Class Finance Development Corporation and the National Scheduled Caste Finance Development. It's a company for non-for-profit Ministry of Social Justice Empowerment, promote economic development activities, and for the fully owned Government of India company facilitate finance, mobilize fund, economic empowerment of the people in the SC category. Important aspect of the governance. So, Ministry of Panchayati Raj, National Institute of Rural Development, Panchayati Raj, Model Panchayati Raj Framework. 3-tier system is basic for 243G. Constitution of India specify the area, health, sanitation, education. Basic objective improve the quality of service, and this bring the professional panchayat functioning and useful yardstick for the monitoring evaluation of service of delivery. Citizen aware about the rights make the panchayat and their elected representative directly accountable to the people. Autonomous organization, National Institute for the Rural Development, Panchayati Raj. So, National Center for the Ministry of Rural Development is the Rural Development. So, the Economic Social Commission of Asia Center Excellence study the functioning of Panchayati Raj, focus on the policy program for the benefits of the poor, democratic decentralized process and efficiency of the rural development, promote the transfer technology park. Transparency will be the accountability, values, quality, standards, and the choice. Vision for mission, detail of the business and the stakeholders, standard service, quality, time frame, grievance redressal. So this is for the first articulated implement in United Kingdom. Now is India has co-adopted the Citizen Charter. Department of Administrative Reform and Public Grievance is for the right to citizen time-bound delivery, goods and service redressal of the grievance, for create a mechanism ensure the timely delivery of goods and services. So its Ministry of Panchayati Raj issued the Mysuru Declaration of the Service Delivery of Panchayat. So aim to recognize citizen-centric core of the governance and declaration for resolve the roll out the common minimum service. So model citizen charter, Rajiv Gandhi Panchayat Sashaktikarn Abhiyan will be there for the promote people participation of Panchayat. Model citizen charter will be Panchayat condition and there will be limit service and alleging the action of the sustainable development. Sabki Vikas Sabka Yojana, Mission Antodaya will be Gram Panchayat, Gram Swaraj will be there. Gram Panchayat development plan for the people plan campaign, Sabki Yojana Sabka Vikas, preparation of the increasing the maximum participation, meeting the Gram Sabha standing committee, Gram Panchayat meeting the elected Panchayat member. Article 243G Constitution of India as the Gram Panchayat to prepare the implement this vision for what is the village like goals, vision and action plan will be there. A comprehensive based participatory process. So Gram Sabha converts the scheme for all related ministry and Gram Sabha is for the 29 subject list 11 schedule. So Gram Sabha preparing the GPDP respectively effective implementation flagship national importance of Gram Sabha. Ministry of Panchayati Raj is model guidance for this. Good Governance Index is for the 25 December governance, citizen-centric environment, judicial public safety, social welfare, economic governance, public infrastructure, public health, human resource development, common industry, agriculture and allied sector. So this is for the exercise Department of Administrative Reform. Public grievance is to assess the impact of the various interventions central state government. 10 sector will be identified. States of category into the 4 group: northeastern, hilly to UT and the Group A, Group B. 20 states improve their compositions and the Group A will be the Gujarat topped and the Madhya Pradesh topped and the Delhi is UT's ranking and the northeastern category is the Himachal Pradesh top. So major policy initiative: improve the socio-economic status, focus on strength of district identity, low hanging fruits, struck the 49 indicators like health is 30%, education 30, agriculture 20, financial inclusion 10 and basic infrastructure 10. Convergence for the central state scheme, collaboration with the schemes and competition. District Good Governance Index is for the Administrative Reform Commission as for Jammu Kashmir and the Good Governance 2026 is for the identify the impact of the various government intervention district level, provide the futuristic roadmap improving the district level government roadmap for the benchmark for this district. Mission Karam Yogi is for the vision of the private for this designed to the developed a framework for role activity and the competency for the central government for the future civil service role activity corresponding every government position, behavioral attitude, functional skill and domain. So this is Santhanam Committee 19 recommendation for the fight menace of corruption. Citizen Service Examination Review Committee for the Yoginder Ke Alag Committee or Testing and the Candidate Common Subjects rather than Surinder Nath Committee for the Suggested Domain. Yugandhar Committee for the recommendation needs of the Surinder Committee, Yugandhar Santhanam Committee, Hota Committee for the introduction of aptitude, leadership and the selection use of the information technology, Baswan Committee for the meaningful assessment of the IAS officer. Mission Karam Yogi is Baswan Committee, Surinder Nath Committee, Yogendra Committee, Hota Committee and the Yoginder Alag Committee. So this is integrated government online tracking iGoat Karam Yogi for the capacity of the bureaucracy and this is for the strengthening HR management policy intervention contribution performance analysis data good setting real time monitoring credible autonomous institutional framework create shared understanding function structure shift from the rule to role compilatory FRAC large scale comprehensive learning platform underpinning the mission enable online offline blending digital rights European Commission for the digital rights so extension of the Berlin Declaration digital society value based digital government EU Council 6 right principles are there digital rights closely linked to the assess create publish digital data extension of the right set up the Universal Declaration of Human Rights implying the right privacy data protection can be trolling online hate speech. So this is the people at the center digital technology protect the rights support the democracy ensure the digital player EU promotes value online environment safe and the legal and the harmful content safe and secure safety security for the old age digital service should be for sustainability green pension people participation engage the democratic process and the solidarity inclusion or not digital divides public procurement or project management Department of Expenditure and the Ministry of Financial Affairs for the public procurement project management goods and service public entity will be different project goods and service purchase the government entity public service so this is general finance rule Ministry of Finance and the procurement the general guidelines for the follow the freedom of agency have the own procurement of the rule so Ministry of Defense Railway and the budget public procurement 50% procurement guidelines Article 246, 88, 98, 99, 300A in Contract Act, Sales and Goods Act, Prevention Corruption Act, Arbitration Conciliation Competition Act, CVC Act. So there is for the WTO agreement, pluralistic agreement for the open, fair and transparent conditions. National treatment, non-discrimination of the agreement for the respect to procurement covering goods and service. India is not a party to but the observance of the government. So this is the better project executive quality via the detailed projects for the report feasibility study of the ground survey and the procedural clarity about the procedural consultation dispute reduction introduction of the incentive allowing the budget based selections strict payment timeline digital trust and the online trading will be there. Other is Lokpal is the direct inquiry into Lokpal Lokayukta Act, National Anti-Corruption Ombudsman Lokpal Lokayukta Act is not below the rank of the Joint Secretary and conducting the preliminary inquiry referred to the Central Vigilance Commission of the Lokpal Bill. So Judicial Lokpal is the Prime Minister, Minister, Member of Parliament, Group A, B. The Lokpal consists the maximum 8 member, 50 judicial member, 50 for the SC, ST, OBC minority. PM, Speaker of the Lok Sabha, Leader of Opposition in the Lok Sabha, and the CGI will be the member. E-governance is the 54th E-governance conference. Hyderabad Declaration, Transform Citizen Service, Umang DigiLocker, UPI using other FASTag implementation of National Digital Platform, faster responsibility of machine learning, Blockchain, 5G, Mighty E-Seva, Gyandut for the MP, Lokwani for the UP, Friends for the Kerala, Bhumi for the Karnataka, E-Seva for the Andhra Pradesh, Gyandut for the MP, E-Seva for the Andhra Pradesh, Bhumi for the Karnataka, Lokwani for the UP, Friends for the Kerala. Digital Media Content for the Regulatory Council for the Digital Media Regulatory Council, Broadcast Digital Funding for the Industry-led Self-Regulation, Mandate to the Information Technology Guidelines, Digital Media and Ethics Rules, earlier known for the Broadcasting Foundation, and the second tier mechanism for the appellate level. This is independent self-regulatory body. New general for this intermediary guideline, digital media rules for this is Information Technology Act and the group of Union Government for the platform, new current affairs and ambit of the Ministry of Information Broadcasting, media intermediary, Ministry of Electronics Information Technology. Important definition of the rule, digital media over the top platform, online content, and the Ministry of Information Broadcasting. Meghalaya Enterprises Architectural Project Mega is for the Meghalaya. Mega is a digital service system, is 6 pillar in architecture, development, implementation, extensive architecture, unity in diversity, business, data technology, and the security integration. Megaya is for the India Vision, One Government India, principle of the reference model. My Government Platform, this is for the launch 7 pillar, 7-year citizen engagement and the engaging the policy formulation, and the My Government Digital India Corporation, Ministry of Electronics and IT. India Internet Governance Forum, so the Constitution Tunis agenda. So India Internet Government Tunis agenda. So group will be the discussion between intergovernmental organization, private company, and internet. Corruption Perception Index, Transparency International 85 180 country. India score for the remain stagnant. So Denmark, New Zealand, Finland. Per level of the public sector corruptions will be there. So India rank country. India is the 0 scale and 100. All India Mayors Conference will be there for the new urban India. Municipal body executive heads elected by the city councillors. Gambling is the state subjects 34 list of the schedule 7. Finance Act, betting gambling is the means putting the stakes something value participating money, consequences of risk of the high, so outcome of the game contents to who's the main determined by the accident or the likelihood any of the not occurring. Entry 40 list 1 is the 7th schedule of the constitution deal with the excluded ambit of the gambling. Government of India Lottery Act is Loda committee consisted the Supreme Court. Recommendation of reforms in the Board of Cricket Control is sharp distinction between the betting and the fixing flavoring. So this is horse racing in the India's that isn't all about the gambling. Several Indian states lotteries, Arunachal Pradesh, Madhya Pradesh, online gambling, land-based cousin illegalized the Goa, Sikkim, and Daman. Maharashtra has prohibited the gambling, and the e-gambling was the Sikkim in Nagaland. Telangana, Arunachal Pradesh, game of the skill illegal. Gambling Act, Arunachal Pradesh Public Gambling Act is there. All India Gambling Federation of Rummy Federation and the Federation of India is there. Internet shutdown for the Parliamentary Committee Information Technology is internet shutdown, international disruption, internet electronic communication specific location caused by internet blackout, social media shutdown. For this is the temporary suspension of telecom service rules notified IT Act. Police Commissionerate E-System, so District Magistrate and the Superintendent of Police share the power and the responsibility. Dual system ST and DM supervising the police administration ensure the lower concentration of power and making the police more accountable. Commissioner head of the Unified Police Commands and has the magisterial power. Deputy Inspector Central of above. This is the power of the prevention, arrest, imposition of 144 power to prevent people entering, removing from the jurisdiction of maximum 2 years. Default bail. National Investigation Agency, Central Bombay High Court order the granting the bail to the activist of the Sudha Bhardwaj. So defaults statutory bail right to bail that accrue while police fail to complete investigation specified period enshrined the code of criminal procedure, and the police 60-day complete the investigation, 90-day 180 days. Supreme Court punishable with the imprisonment 7 year ordinary summon issued to the accused, and bailable warrant issue later a non-bailable warrant punishable to the death imprisonment, life punishable to the special court, and the economic offense will be there. Parole and furlough. Paroles are the parole granted to the meet the specific exigency. Furlough granted stipulated number of the year to the serves without any reason. Parole is system releasing prisoner suspension of the sentence, and furloughs is granted to the prisoners treated as a remission of the sentence. Parole is for the suspension of the sentence is suspended. Furlough is for the furlough is for the furlough is for the remission, is for the suspension, that is remission. This exigency is without any reason and does not have any absolute legal right. Prison convicted multiple murders and anti-terror unlawful act not eligible for the parole for the must have balance against the public interest and can be refused to certain category of the prison. So PM care fund is for the PM care fund is not furlough is for the remission, that is for the suspension. This is exigency, this is not any reason for without any reason for furlough. So PM care fund is for the PM care fund is not a government fund collected by it's not to call the Consult Fund of India, but public charitable trust under the Prime Minister's Citizen Assistance for the emergency situation funds and dedicated national funds for objective dealing with any kind of emergency distress and the provide to relief to the affected. Prime Minister is the ex-officio chairperson. Ministry of Defence, Ministry of Home Affairs, Ministry of Finance are trusted fund. Any contribution made by PM care funds are qualify the corporate social responsibility. 100% exempted for the exemption operation. All of the Foreign Contribution Act will be there. Revision rural area development plan right fee guidelines. So that this is for the special development typology of village population, agroclimatic zone disaster. For the village town planning will be the linking 15 Finance Commission cluster rural 74 and the e-governance. So the spatial infrastructure Swamitva is for the their rural rule to the post retirement hiring of official government organization. Central Vigilance Commission followed the government organization getting the vigilance clearly, and as for the clearance has to obtain from the where the persons was during the 10 year prior to the retirement. Formulating appropriate rule for the employee for this is observed from this. So next is anti-convention law for the states of Madhya Pradesh, Sarla Mudgal case, Lata Singh case and the Chandra case. Universal Civil Court Shahbano case, Sarla Mudgal case and Daniel Latifi case. Sedition is for the Romesh Thapar case, Kedarnath Singh case and the Kanhaiya case, and the reservation promotion for the person of disability, which is the sedition for Ramesh Thapar case, Kedarnath case, Kanhaiya case. Reservation promotion of person with disability, Siddha Raju, State of Karnataka, and the National Federation of this. Office of Profit Pradyut Badloi case, Jaya Bachchan case. Appointment of this Director General of Police Prakash Singh and the Union of India case. Collegium system for appointment of judgment of high courts for the judge of case. So this is all about